Our next presentation is on Rideshare. It's presented by senior trial lawyer Neil Solomon and firm partner Jack Zinda.
What I want to talk about next are rideshare cases. This is a hybrid version of a commercial vehicle case. It's not quite a motor vehicle case. It's also not quite a trucking or commercial vehicle case. It's a little bit different. And this is a very state-specific area of the law right now. In the past, it was kind of the Wild West, and there were no rules that necessarily regulated how these cases apply. But before we get into the specifics of how to handle a rideshare case, I wanted to set the stage and first give us some definitions about what is a rideshare case, what laws are going to apply, and then also we're going to talk about insurance coverage issues you may encounter and the different types of fact patterns that you might see. So the first thing to know is a rideshare is a transportation network company. That means that it's connecting a driver with a passenger, and the app itself is essentially a way station, and they're taking a part of the charge as their fee for doing it. They don't consider themselves actually the ones that are transporting anyone from A to B, and they like to consider themselves as independent contractors. And that's going to be a very state-specific guidelines that apply to those. The two main players, I'm sure as everybody knows, are Uber and Lyft. There are other companies that these rules apply to, and you'll also see it in the context of food delivery, such as Uber Eats, DoorDash, and Favor. But one thing I want you to take away from this is that it's going to be very state-specific. Most states have enacted their own laws at the behest of lobbying from these various companies. In Texas, the rule is controlled by the Texas Occupations Code, Section 2402, and in Colorado, it's controlled by Section 40-10-6-01. And these provisions lay out the type of insurance coverage that's required, and also it goes into what's required to be a driver for a rideshare company and specific regulations on those. So first, there's certain offenses that would disqualify a driver from working for a rideshare company. In Texas, the first thing to know is the driver must be 18 years of age. They have to undergo a background check, and the TNC, which is the Uber or Lyft, has to review their driving record. And then there's a list of offenses, if they do have these, that they will not be able to drive for the rideshare company. Now, they're not required to get fingerprints as part of the background check, which was relatively controversial in Texas. There was a lot of back and forth on that particular issue. If you do get a case where a rideshare driver injured someone or caused a wreck, you want to go ahead and run your own traps to see if maybe they were in violation or the rideshare company did not follow the right procedures and provisions. Now, what I've seen in almost every state I've looked at, whether it's Texas, Colorado, California, that the objective of these laws was to make the TNC an actual general contractor and not have them culpability like an employer would be in a typical driver passenger situation. So go to the next slide, please. In Colorado, the driver has to be 21, not 18. They have to have a certified mechanic conduct a safety inspection of the vehicle, and they also have to undergo a background check as well.
So I was going to jump in and you can kind of compare and contrast a lot of the disqualifying offenses that you can have on these different states. And so in Texas, if you have over 3 moving violations, any fleeing or reckless driving charges, or driving without a valid license, then you cannot be a driver in this scenario. In the past 5 years, you can have no DWIs, no use of a motor vehicle to commit any type of felonies, and then also you cannot be on the sex offender registry. In Colorado, it's a little different. They extend it back a little further, so you can't have a DUI in the past 7 years. There's a zero tolerance for any sort of fraud, unlawful sexual behavior, offense against property, crime of violence, or greater than 3 moving violations in the prior 3 years. So you have to look at what's in each specific state's code to figure out, is that person an independent contractor or not? In Texas, we looked at the Texas Occupations Code. And basically, if there are no prescribed hours, there's no restrictions on driving for other companies. So you can't say you can only drive for Uber and limit their ability to drive for Lyft as well. No territorial limits. So telling them you get the airport or you get this part of town, they're required to allow the drivers to pick where they go to. And then no restrictions on other occupations. And then on top of that, the independent contractor status needs to be put into writing. And so I can tell you that in fact, they definitely do require the rider or the drivers to put into writing they're agreeing that they are classifying themselves as independent contractor status. This has been fought in a lot of other states, but at least in Texas, they have been found to be, for the most part, independent contractors. And it's very, though, fact specific on what those factors are. The other part of it is that it requires that they provide coverage if a driver's policy has lapsed or doesn't provide the minimum amounts of coverage. And so they lay out in the Texas Occupation Code about these types of companies, and that if you're a logged in driver, and we'll talk about that in a second, that you have to have certain types of insurance coverage available. So the same thing applies for Colorado. There's statutes that lay out exactly what's required. The driver has to have liability coverage involving the driver for a prearranged ride. And then there's a requirement of at least $1 million in coverage. So there are different phases of the rideshare. So when you go through it, phase 1 is when you're logged off, okay? This is when you are in your car, you have not logged into the app, and you're driving around or sitting at home for that matter. Once you get in your car and you turn on the app and you're looking for rides, that's considered to be phase 2. You're searching for a match to actually find a ride with someone. Phase 3 switches to when you're actually matched with a driver and you're on your way to go pick that person up, but they haven't yet entered the vehicle. It switches to phase 4 once you actually are driving that person and they're in the middle of their ride. And then phase 5 is when that person has exited the vehicle and the ride is completed. So we discussed that when your phone is off, it's your own personal coverage. And each state lays out what the mandatory minimum requirements are for each particular state. So in Texas, that would be a 30-60 policy, meaning 30,000 per person or 60,000 per incident. And then your own UIM coverage would apply as it would. If you're in Colorado, that would then be 25-50. Each state is going to classify what that would be, and you need to look into that specifically. Phase 2 is that you're categorized as having actually turned on the app and you're looking for someone. So now you have it to where it adds an additional liability coverage. So it's $50,000 per person or $100,000 per incident, and then property damage as well through the actual TNC. So that'd be $25,000 in Texas and $30,000 in Colorado for property damage. When we head over to the next phase, which would be phase 3 and 4 for that matter, if you are actually on your way to go pick up the ride, it then flips over to having that full commercial liability. So that would be that full $1 million in coverage, and that is through different insurance companies, and it's dependent upon the state. So we've seen these TNCs switch from different providers of insurance throughout different states over the past couple of years. With that, you're going to see $1 million there, and it doesn't necessarily specify any requirements related to the UM or UIM. Originally, there was a time when there was $1 million in coverage. We've seen most of the companies back down to $250,000. And you need to specify or look specifically to the policy to see what's available there. So in these particular liability scenarios, the first one is an example where mother-daughter weekend, Debbie is driving her visiting mother around. Uber driver makes a left turn into Debbie's car. And so what are the sources of recovery? So at the very basic level, if the Uber driver is at fault, assuming that they had a passenger in their vehicle, then they have $1 million in coverage that you would be able to go after on behalf of Debbie. The other areas that you want to be looking for are what sources of recovery they would have in their own vehicle. So obviously you have Debbie, who was the driver of the vehicle. You would have her potential UIM insurance or PIP or MedPay or other coverages that might be there. And those would potentially come into play as well. And then on top of that, mother is visiting. She would also potentially have her own policy if she had any related to UIM, PIP, MedPay, and looking at all of those. But on the liability front, the primary would be that Uber policy or Lyft policy. In the next instance, we have Sally, who's an 18-year-old college student. She took a job driving Lyft. She took a Lyft to her babysitting job. That Lyft driver, when she was a passenger in, made a U-turn and caused a collision. The driver was cited for failure to yield a right-of-way. And so where can she recover from? So the first step is she can recover from the liability coverage from that Lyft driver. And then again, if she has her own policies, whether through herself or through her parents or otherwise, then there may potentially be additional UIM, PIP, or other MedPay type coverages. We've generally found that there's not included PIP or MedPay included in these coverages, but you do want to make sure that you check the policies and see what's available to each person. So the next instance is a girls' night out, Patty and Peggy, at night on the town. They take a Lyft back to Peggy's house, and their vehicle was rear-ended. So this caused their vehicle to crash into a vehicle in front of them, which was an Uber ride with passengers. So the at-fault driver was insured. So what are the sources of recovery? So you always go back to, well, who is actually at fault? And so you start with the coverage that is available with the party that caused the collision. So in this instance, it would still be that Lyft driver, their vehicle that was rear-ended. So the driver that rear-ended them would be the one that's responsible. And then you would then look at any internal UIM policies. And so one of those would be each individual driver, if they had their own policy, that would come into play, as well as with Lyft, they would have a UIM policy or uninsured or underinsured motorist if their injuries and damages went past the original at-fault driver. So you're looking at all those, and you can also check, like I mentioned before, PIP, MedPay, any other coverages that might be there. So you really have to map out what are all the policies that are there. And then in this instance, when they got pushed into a vehicle in front of them, more than likely there's no coverage there. There's nothing wrong that that party did. But you want to make sure you're doing analysis of all the vehicles that are there. So the last example that we have here is Danny the driver. He's a full-time Lyft driver, and he has a passenger. So he's in that stage 4. Another driver ran a red light and hit a vehicle. That vehicle spun across the intersection and hit Danny's vehicle. So now the at-fault driver was arrested for a DWI, and the at-fault driver was uninsured. What are the sources of recovery? So if that at-fault driver has no insurance, and you've confirmed that, you obviously want to make sure that's the case and run all those traps. The second step would be is the UIM related to the Lyft. So you're going to check that coverage, see what's available in your state, and that's the first place you look. And there's also going to be coverage potentially through your own personal insurance that would have been there. So if you are a driver yourself, you're a passenger, you're checking for your own UIM. Now, in this particular instance, going down the line, what other sources of recovery are out there? How bad are the injuries? Looking at a potential dram shop type action is always something you want to look at if the damages warrant them. But the first places that you're going to be looking at are going to be the at-fault driver and then UIM through your own company as well as your own personal policies that are there.
Well, jumping into a few more items that I wanted to hit, and Neil, in your experience, what has been the approach when filing a lawsuit? Do you find that it's good to include Uber and Lyft in those suits, or do you just file the suit against the driver? What's been your experience on that front?
Yeah, so in my experience, and I think there's a real conflicting analysis on this among really smart attorneys. So I don't think it's a one-size-fit-all approach for this. I generally have brought in Uber into the case, or Lyft. I think that it adds another analysis. It looks at it from multiple angles. It could create additional work and other things you have to look at. Most of the time, you're going to see yourself having to discuss and deal with that independent contractor status, and Uber and Lyft trying to get removed from the case through a motion for summary judgment or something like that. And so, but I have found that it can be valuable. Getting another larger company involved, I think that in the actual case, you're going to be able to talk about Uber or Lyft and what they were driving for at the time. And I think it's helpful to have that risk manager or adjuster from the actual company be involved so that they're part of the analysis and kind of watching to see what happens with whoever the attorney is for the carrier that's actually covering the individual driver.
You know, and what I've seen, I think in some instances, they may be violating their own terms that they agreed to when these laws were enacted. For example, I've talked to several rideshare drivers, and they've told me that they get kicked off the app if they don't drive a certain amount of hours or if they're not available at certain time periods. Which, keep in mind, no one is monitoring what Uber and Lyft are doing proactively, in my experience at least. The only way these issues pop up is through complaints or litigation. So I think it's smart not to wave the white flag on bringing Uber or Lyft directly in, because they're constantly modifying these things, especially right now when they're strapped for cash and maybe business isn't as good, to where they could cross over into respondeat superior. You know, another thing that I think is really important is how you conduct discovery. Neil, what are some of the things that you've seen that's important to keep in mind on discovery in these types of cases, whether it's in the pre-litigation stage or actually written discovery or depositions itself?
Yeah, so one of the main things is you're obviously using your phone as a tool as one of these drivers. So, I think we talked about earlier is making sure you're sending a spoliation letter out, telling them to maintain the cell phone. You always have to do an analysis on your case as to what your damages are versus what needs to be done on the case or what you can afford to do on a case. But if you can, it's hiring a forensic expert to take a look at the phone, ensuring that you're getting the data from what they were doing at the time, where was the phone being held, and then discussing all those things with the driver as you're going through it. I've seen in depositions where they were distracted by their phone, and that's what caused the crash. I know that's been litigated by other people as well. And the other thing I think is really important is making sure that you prepare your client for what's going to happen. What the defense is going to ask them a lot of questions and try to establish some of those relationships, independent contractor or not. And I think you can just kind of scare your own client about, well, I don't know anything about this, and preparing them for those questions that might be coming and making them feel comfortable for their deposition.
Well, and there's so much data that is in the phone now. I know Uber and Lyft are tracking the speed of their drivers. They're tracking the number of drop-offs. And I take, or pre-COVID at least, I took Uber and Lyft quite a bit. And I always would talk to the drivers about their experience with the app, how it works. And I was talking to one gentleman who was saying that he had just done 8 hours on Lyft and he was going to do another 8 hours on Uber and just switch it over to the next driving app. And I think that could create some additional exposure for them, putting really unsafe, tired drivers on the roadway on information that's easily available. And as far as I could tell, there was no questionnaire they were going through or anything like that. So we always try to go after the phone, go after the data, and we want to make them feel uncomfortable because they don't want to share that information with you. And I know one of their big incentives is trying to get as many drivers on the road as possible. And so that's where they start cutting corners, or they could potentially be cutting corners. So go after the data, go after the phone. If you need to get a forensic or a software expert, I would take that approach. Um, one interesting case we had recently, one of our attorneys at our firm, was there was a wreck involving Uber, and the Uber driver actually asked our clients to get out of the car before the police arrived, because they didn't want to get cited that they were driving for Uber at the time of the wreck, because that would get them kicked off the platform. And so that was an interesting wrinkle, and it created all sorts of issues in the case, because when does coverage kick in? What sort of things, which coverage would apply in that instance? So keep that in mind. Some other things that you want to think about is how to break down these cases. And I'm a big checklist person and a big process person. So I always whiteboard out, and every office in our firm has a whiteboard where we write out, okay, who's involved in the wreck? What are all the potential insurance policies available? And we'll go through that same process we went through before on which stage it is, UIM, liability, et cetera. Make a list of everyone who could be at fault, and then try to identify that phase. And you need to do discovery at several different levels to figure that out. This also brings up that you need to be asking if the person was driving for a rideshare company at the time the wreck occurred, because you're not always going to know that based on a crash report, because the driver may not reveal, like in our case, that they were actually driving for Uber or for Lyft. Neil, what are some other tips you can think of in regards to these cases, whether it's how to negotiate the cases or how to deal with these companies?
Yeah, so the big thing I would say is I wouldn't treat it like a normal car crash case. And so one of the big things is just from the very beginning, treat it differently. There is going to be more coverage available. And so making sure you understand that and working it up appropriately. And I think that, I think that a jury will, when they know that's there, they've all been in one before. And I think they do expect that a driver is going to do and not necessarily have increased training, but hopefully they would. But they're entrusted on the road by this large corporation, and they're handling a lot of rides. And so if that's the case, I think they're going to hold them to a higher standard. And so I think, holding these companies feet to the fire and making sure you're approaching it differently than just your standard case and closer to, like you mentioned, this is a commercial case, a commercial policy. And this is basically a professional driver who's out there on the roads. And so treat it that way.
And the other thing to keep in mind is the jury's going to know that there's a large source of recovery if they know they're driving for Uber or Lyft, whereas in a regular car wreck case, they may not know that. And so what we find is of course, the defense wants to play the sympathy card of this poor person who couldn't pay a big judgment, even though they're not allowed to talk about source recovery. They try to imply that. When you're dealing with rideshare, I don't think that comes in as much. And what we found is the more aggressive we are in these cases, the more likely they are to try to resolve it for very fair money, opposed to holding back and not being aggressive. And I think going after that data can really help. If you want any parts of our discovery or petitions or pleadings in these cases, reach out and we're happy to share those. Neil, do you see any difference between Uber or Lyft when it comes to how they approach these cases, or does it seem pretty similar, the two?
So I think one of the main things is it's actually very either carrier or adjuster specific. And so it's been interesting to see how it's gone across the years, how it's first James River Insurance, and then in some states they still are, in other states they've switched to Progressive. I've seen York Risk Management was handling these cases. And so I think you really change how they've been being handled by the growth of these companies, and then the change in how these insurance policies have been written and how they're just being handled generally by the company. And so it's a pretty broad question. I think the answer is that it's just been changing over time. And I think you'll find with each specific one, each one has been different. Some have been disorganized, some have been really on top of it and have been really responsive and wanting to get cases done, some of which in pre-lit. So each case is different, and you just want to see from each adjuster how they're reacting and how responsive they're being.
And I know when we mentioned early on in the case, or not in the case, in the presentation, about the differences with food delivery companies, and just know a lot of these rules and coverage issues don't apply in necessarily the food delivery space, whether it's DoorDash or Favor or Uber Eats. And you're not going to have the same source recovery and some of the other things we talked about here. And those apply a little bit differently. So keep that in mind when you're looking at these. Well, hopefully this has been useful, and look forward to talking to you guys a little bit more in a minute.
Thank you.